Chairman Klein. I'm proud to have introduced this resolution, and I appreciate the opportunity to speak in support of it today. This resolution is about standing up for the rights of workers and employers. Let me say that again. This resolution is about standing up for the rights of workers and employers. The Obama administration, those that support them in this issue, have continually put the interest of union leaders ahead of what's best for hardworking Americans. It's disappointing because working families are struggling in today's economy, which we recently heard is growing at the anemic rate of only about 0.5%. Over these last 8 years, their wages are stagnant. Instead of focusing on ways to grow the economy and empower more Americans with opportunities to move up the economic ladder, the administration has been working around the clock to check off their big labor wish list. The latest example is Department of Labor's persuader rule, which radically alters long-standing policies employers must follow when communicating with their employees about union-related issues. The well-established advice exemption of the Labor Management Reporting and Disclosure Act has been in effect during the Kennedy administration, the Johnson administration, the Carter administration, and the Clinton administration. But now, decades later, the Obama administration, at its very end, is working around Congress and unilaterally rewriting the law. As someone who has practiced labor law, I know firsthand how complicated and confusing Federal labor policies are. I'm from Southwest Alabama, where we don't have many large employers, but we have many small businesses. When faced with a union organizing campaign, most of these small companies don't have HR departments or in-house attorneys to turn to for advice. So they find someone like me to help them understand what the law is. However, the invasive and costly requirements under this new rule will severely limit the ability of small businesses in Alabama and across the country to get the legal advice they need and deserve. They'll be stripped of their confidential attorney-client relationship, and this has been verified by the American Bar Association, and they will lose their fundamental right to counsel, and as a result, they'll be forced to fend for themselves. Many small businesses, despite their best efforts, will inadvertently get tripped up while trying to navigate a maze of labor laws on their own. I've seen this with many clients over the years who are simply trying to understand and follow this very complicated law. If employers cannot get basic legal advice during union elections, many will reluctantly choose to not say anything at all to their employees. And that is exactly what unions and the administration and the supporters of the administration want under this extreme and partisan rule, to silence employers. But who loses in this environment? American workers do. Let me say that again. American workers lose in this environment. They'll be deprived of the information they need and they deserve before they cast an important vote on whether or not to join a union. Workers will hear from union organizers, but they won't hear the other side of the story, how this vote will impact their paychecks, their benefits, and other personnel matters. And again, that's precisely what the administration and their labor allies want. They aren't interested in fair and democratic union elections. Instead, they're interested in tilting the balance of power toward union bosses. That's what this is all about. As members of Congress, we don't have to sit back while the administration tramples on the rights of employers and employees. We have the power, we have the responsibility to block this harmful rule under the Congressional Review Act. And we have a choice. We can stand with big labor, or we can stand with America's workers. I urge my colleagues to stand with America's workers today and support this resolution, and I yield back the balance of my time.
The gentleman yields back. Are other members